Are you seeing subject twos and wrap notes a lot at all? Or are you getting involved in that or have an
Not,
opinion about that?
it's not something that's really presented to our firm that
Okay.
much. Not, I mean, I would welcome it. I'd be very happy to look at that. We're mostly busy right now unwinding on the tail end of a good pool of HECMs, second mortgages that we got,
Yep.
the land contracts, and then we have some traditional first.
Gotcha.
But no, I mean, am I open to doing the work? Yeah, we're just not seeing a big flow into our firm right now.
Gotcha. Have you seen owner finance paper written not so well?
Yes.
And what are some of the biggest issues you've seen in owner finance paper that written incorrectly?
Or
So
common things even.
And why does it matter if it's written incorrectly for those who are new to the show?
So when I think of seller finance paper, the stuff that we're seeing a lot is we're seeing land contracts or contracts for land contracts is what they call them in Ohio. So I tend to fall to that, but it's contracts for deed.
Yeah.
That carry with them a note. And I don't know that in every state that's wrong per se, but I do think in some states, you're going to have some courts, when it gets litigated seriously, balk at that a little bit. So I would say be very careful when you do that. I understand why you would want to do that. You want a promissory note that you can enforce, and you're looking for a way to secure that promissory note with an interest in the mortgage. But a land contract is actually intended to be a glorified rent to own.
Yep, lease option. Yep.
So, and even in the enforcement of that, most states have a threshold where below which it's a forfeiture action like an eviction, but above which, if there's more equity paid or they paid over a longer amount of time, then it's an actual foreclosure.
Yeah.
I worry sometimes about the homemade drafting of those contracts. Most states, fortunately, give you a statutory form for a contract for deed or a land contract.
Wow.
So I would love to sort of be on the front end with some investors who are looking at doing the deal and kind of consult and advise, hey, let's look at how we want to do this in Tennessee or South Carolina. I'm not licensed there, but my associate is, but we have a lot of work. How do we want to structure this sort of deal so we can get you security and get you a promissory note?
So let me get technical for a second, because I agree with you. Going way back when I was doing land contracts in Ohio, and I wouldn't do a note because I'm like, it didn't seem appropriate to do both. So and then when I sold just that land contract, then they're asking for allonges, and I was like, but there's no note.
Right.
So why would I give you an allonge
for
a note that doesn't exist? And I always thought that was so weird. But I was like, sure, I'll sign it for you if you'd like. But
well, the great thing about a land contract is you own the property.
Yeah.
So I mean, it sort of seems a little circuitous to try to then loan money and get an interest in a property that you already own. I mean, you are already secured. Because when you bought that land contract, you should have, I guess there's feasibly a way to do it differently, but you should have gotten a quitclaim deed of the property to you.
Yeah.
Then you have assignment of rights under the land contract. So you are now the assignee of the vendor of the land contract, but you own the property too. And if they don't pay you under the land contract, you can either make them forfeit it or you foreclose.
Well, that's interesting. I don't think I ever did that assignment of rights, but that makes sense.
Well, I think that's what a lot of people are doing when they're trying to do just an assignment of mortgage, that they just take the word mortgage off of it and they write land contract or contract for deed in there.
Right.
And functionally, it's probably doing a lot of the same thing.
Sure.
Could there be a unique and a sort of custom tailored document to meet that solution? Yeah, I think so. But I also understand too that not everybody's excited to pay an attorney for a half a day's work to do that. You've got to watch your budgeting, especially a lot of these contracts are lower value. So I don't fault anybody for making a business decision as long as they're doing it with good advice on what the risk and reward is of that.
Absolutely.
So those are my general thoughts on that. But
so we had a quick question over on LinkedIn from Don McAlpin. I apologize if I'm butchering your name, but what type of title curative issues are you seeing with CFDs, and are they state specific?
So most CFDs, land contracts have state-specific requirements. Most states require in the statute that it be recorded. So one of the things I see a lot of the time is a land contract or a land contract that has a modification, and either are recorded or the modification isn't recorded.
Mhm.
It's depending on the state. Some people will say, hey, look, you as the vendor under the land contract had this responsibility to do it. And if anything in the transaction looks questionable or even is presented to the court as fraudulent, you may run into a problem.
Mhm.
Now, we're not trying to defraud anybody. We're just trying to get somebody to pay us to live in the house.
Right.
But recording that land contract up front can sort of cut that argument off at the knees.
Okay.
So I'm seeing that. I do see something that we've already mentioned to answer his question is, how are we assigning that land contract to the next guy?
Gotcha.
Are we doing that with, if we do have a true note, if it's a true negotiable instrument, then yeah, an allonge would probably be appropriate for the note, but not for the land contract.
Correct. Yeah.
Mhm.
So those are some that pop up. I'm sure there are others out there that just I'm not thinking of.
Yeah. And typically you do a quick claim, right? Is that typically how you do the transfer of the CFD?
Yeah, I mean, you could do a quick claim deed, which is probably the cleanest for you as the transferor, because what you're doing in a quick claim deed is you're just quitting any claim you have to the property. It's yours, whatever I owned, you now have. You could potentially do a special warranty deed. So it's not a general warranty deed. You're not saying I warranty this property against any claims of third parties, but you might say, hey, I own this free and clear, all except for this land contract, and I do a special warranty deed. If you do that, maybe there's a chance you can get title insurance to cover the transaction.
Awesome.
Something to think about.
So let's dive into the dirty stuff here, right? Give us one scenario that most note investors think is fine and easy, that a collateral file review that, goes into. But before we go there, what does collateral review actually mean in your words?
So it's something that I was asked to do starting about 6 or 7 years ago. Somebody said, hey, will you review the collateral file for us and give us an opinion? Rarely do I give a full legal opinion, but I will give some advice. I'll point out some red flags when people come to me and ask me to do that. So when I think of collateral review, it is opening what's usually a zip file that contains everything that the seller of a note is presenting, either for review by a potential buyer or to the actual buyer, what they have. They've got usually the note in there, or whatever the obligation is based on, land contract. They've got maybe a copy of the deed, maybe they've got an old title report. They should have a copy of the note and the mortgage at minimum, with assignments and allonges that assign that mortgage or transfer that note. Love to see a payoff statement and a payoff history, if I can see that, and then the servicer transfer letters. So that's sort of the package deal that it would be great to see. Usually about half of those things are missing, right?
Yeah.
So that's the business, right? You're going in and you're trying to evaluate, what do I have? What can I ask for? And if my seller doesn't have it, where do I go to get it?
And why does it matter to have those items? What's I'm playing the
no, it's a great
question. What if I don't have this stuff? So what?
Yeah. Who cares?
So who cares? So that's the great question. The court may care if you're trying to enforce it. So what you have to do when you go into court on a foreclosure matter, or you do a non-judicial foreclosure, you're representing that you have standing. The standing to legal term of art means you're the right person to be enforcing this interest. You have standing to foreclose. You can't establish standing if you don't have rights to enforce the note or rights to enforce the mortgage. And each state has a little bit different definition of what's required for standing. So that's the first thing. You have to establish your standing to foreclose. The second thing is, you might have standing to foreclose, but you might not know how much is due. If you don't know how much is due, are you going to be comfortable going forward? Is your attorney going to be comfortable going forward on a homemade calculation on a napkin? Mm-hmm. Sometimes the napkin calculations are better than some of the others I've seen. But are you going to be willing to go into court and swearing before a judge that this is the amount that's due? because we all know if you get that wrong, then the debtor can come back on you for consumer law violations.
Sure.
Those are some of the red flags. That's why it matters. The other reason it matters, I think, mainly to your audience on the front end, is it helps you value the amount of the asset, right?
Yeah, of course.
So if you look at it and it's missing a lot of stuff, are you going to have to pay somebody like me, 4, 6, 7 hours of work to fix that so you can then go enforce it? Or is it pristine? If it's pristine, then you don't have to pay me to do any of that stuff. We can just go right through the process. So those are some of the reasons. Those are some of the whys why collateral review matters. But in my world, it's really about avoiding the red flags.
Sure.
Before we go into court or before we file for a non-judicial foreclosure, do we have all our ducks in a row, or are we going out there risking an FDCPA claim or a state law claim?
I also make sure when I send over that kind of stuff, the O&E report, is in there because it shows the chain of recordings in the county records, just so that the attorney can see the quick chain and say, yes, 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 yes. Whoa, why is this missing? And that kind of stuff. So I had that in there.
And we've said this before, but I'll get your take on it. Most things are fixable. It's just going to take time and money and effort.
I think that's right. I've had one where, the mortgage was gone and the note was gone.
Wow.
Missing or released?
Gone, missing. So, and no lost note affidavit. We just, had some very bare bones information that we could say, okay, well, there are mortgages and assignments of record. Mm-hmm. So we tiptoe into court and we do a quiet title and declaratory judgment action. We're not seeking to, foreclose. We're not seeking to collect. We're seeking to just clean up the record. Mm-hmm. Now, this was in Massachusetts. You got to do that first before you go to land court and you foreclose non-judicially. But we did that. And funny enough, nobody could understand why we were there. Everybody thought we were trying to foreclose, and we're like, no, we're trying to fix things. Well, we got the declaratory judgment that the note existed. Here's the amount that's due. And our client was a party entitled to enforce the note. We got the quiet title action that the mortgage existed. It was assigned eventually to us. And we got an order that we were able to record in the Register of Deeds that said that. So we were able to sort of put Humpty Dumpty back together again.
Wow.
And go to foreclosure. But it took a long time. It's not cheap, but it was fixable, to your point.
That's amazing.
So that's a good example of that's a pretty messed up file when you get that. There's no mortgage in there.
I'll skip it because I'm like, there's no way, right? That would be
exactly.
The first, or I don't want to deal with the hassle.
Unless I'm getting it for a really good price, but
the good thing about mortgages is that they're usually recorded on the front end. But if you're missing any assignments of mortgage, and you don't have a mortgage in the file, it can create some roadblocks, but most of the time you can get around it.
So in a situation, similar to that, like something like that, where it's a missing note or something like that, do you ever use estoppels? And are there any limitations?
And what is estoppel just for those who don't know?
So an estoppel certificate is something where another party has agreed to provide you with evidence or subordination or some other rights or proof of rights in the property. It's Nathan. It's not something that's come across our desk, to be honest with you. I mean,
really,
I could sit here and tell you, and make something up, but I'm not going to. It's just
and they're not common. I've only in files I've bought every once in a while, and it'll be something. So the way that I've had them in the past is, I think they do it as a matter of practice, but some people that I buy notes from in Texas, and they're seller finance notes, and before they sell me the note, they'll go and get an estoppel. So an estoppel signed by the borrower and signed by the lender, both attesting to, we both agree that the unpaid balance is X.
That's awesome.
So that there's so in case you're going through and having to prove something, well, then you've got that estoppel to lean back on and be like, well, they said this was this, we said it was this, we both agreed to that point. So there you go, judge. We'll take it from there, kind of thing.
Well, I'm writing that one down because that's great. Usually I see estoppel certificates in our commercial leases that we do for our non-foreclosure clients. So you're doing like a lease for a shopping center, and then the parties agree that if they ever need to cooperate to permit a new loan to be had on the property or against the property, the estoppel certificate comes into play.
That's awesome.
They're certainly not common, but I do see them every once in a while.
So let's get into the dirty stuff here, right? Give us an example of something that us note buyers may not realize.
Okay. So I used to have a radio show, and what the producer told me is, don't be afraid to keep telling folks stuff you've already told. So I'm going to tell you guys some of the stuff that I talked about at DME. So one of the things that I don't see as much anymore, but it pops up, is home equity lines of credit and allonges. So you have to understand that in order to, an allonge, I'll just do it like we're all new at this, right?
Yes.
So an allonge is the document that you would attach to a note to transfer that note from yourself to the next person. It takes the place of a stamped endorsement on the note.
Mm-hmm.
It has to be affixed and attached to it. It's supposed to travel with the note.
So just real quick before we go there, so just imagining a check for those who are, our age and older, and in the back of the check, if someone signs it, they then signed and you endorse it right below it, and that person now signs it. Now they are the bearer of it. That's exactly the kind of concept we're talking about. Just imagine the fact that instead of signing the back of the check, you're attaching a paperwork and saying, I'm now assigning it with this paperwork with that check. Oh, sorry, Dan.
Yeah, no, I mean, personal checks and notes are in the same family. It's kind of like an otter and a beaver, right? They're in the same sort of family. On a note, on a check, you write pay to the order of, and you pay to the order of that person. And then on the back, when that person endorses it, they can then endorse it, pay to the order of David, and then David can pay to the order of Nathan.
Yeah.
Same thing with notes. You can stamp it on the note. You can create an allonge that basically says pay to the order of this next person. The reason you can do that with notes and checks is because both are covered under the UCC. It's sort of as a negotiable instrument. But home equity lines of credit under many states' rules are not in the same family. So you've got the otter and the beaver, and then you've got this like I don't know, alligator over here is the home equity line of credit. He's not in the same family. He kind of does the same thing. He swims in the water, but he's a different animal. So a home equity line of credit, for instance, in Illinois, is not deemed a note. It's not even deemed a written contract, even though it's on paper. We can talk about that later. But an allonge only can transfer and negotiate a note. You have to do something else to transfer a home equity line of credit. The reason it's different, that home equity line of credit, it might say I'm going to loan you up to $240,000, but it doesn't say I have loaned you this.
Gotcha.
It'll say you can pull down this credit line for a period of 10 years, and that's the first draw period, and then the second draw period, and then there's different interest rates. But you never really know how much you're going to pay each month until you get a statement. Not so in a note. A note tells you here's how much you got to pay each month. So the notes are cleaner. They're more like a check. They can be assigned by an allonge. Now, why do I say all this?